Welcome everyone to this Federalist Society virtual event. We're sorry for the late delay, but we're about to get started here in earnest. This afternoon, July 8th, 2021, we have an event panel discussion on severability and Article 3 powers. I'm Nick Marr, Assistant Director of Practice Groups here at the Federalist Society. As always, please note that expressions of opinion on today's call are those of our experts. Very pleased to be joined by a great panel. They'll be introduced shortly. I'm just going to introduce our moderator. Before I do that, a note for the audience. We'll look to you for questions towards the end of the program, so please submit those via the chat function so we can take them as we go along. Appreciate that. So with that, we're joined today to moderate this discussion by Ms. Megan Brown. She's a partner at Wiley, formerly Wiley Rein. Her longer bio can be found on our website on this event page specifically. So with that, Megan, thanks very much for being with us. I'll hand the floor to you.
Awesome. And I do like the shorter intros. That's fabulous. So thanks everyone for joining us today. My private practice is pretty varied at this point, but as is relevant to today's conversation and why I was excited to join, it touches on really important questions of federal power, including statutory interpretation and judicial review of acts of Congress, as well as agency action. Severability has often been at issue as we look at invalid parts of law or regulation. It informs both our view of sort of the constitutional powers of Article 3 judges, but also litigation strategy and some of the decisions that are made about whether and how to challenge legislation, including some pretty important cases in recent terms. Today's event is as timely as it is heady because it goes to one of the more interesting questions of Article 3 power, as well as sort of high stakes litigation that we all watch, especially as the June month comes to an end and we're all watching for our favorite cases. And the question is, what should the Supreme Court do when it finds a provision of a statute unconstitutional? We have some really fabulous speakers here today to sort of walk through their different views, the doctrine of this, but suffice it to say there's a significant split right now between some of the justices on this question of what to do where Congress hasn't provided express instructions, or perhaps when they do have a severability clause and what the presumptions are going to be there. Several justices think that courts should save the rest of the statute, while others express skepticism about this, really raising it as a separation of powers question. So I'm going to introduce our panelists, and then we're just going to dive in. They're going to give some remarks, and then we'll open it up to questions. So Will Baude is professor of law at University of Chicago, where he teaches federal courts and con law. He's written a bunch, he talks a bunch, he's a big thinker on these issues, and I look forward to hearing what he has to say. He's going to kick us off in a moment with sort of the thumbnail sketch of severability for those of you who had to dust that off from your federal courts class. Kevin Walsh is assistant professor at the University of Richmond, where he teaches and writes about federal jurisdiction, con law, and complex litigation. He has focused a lot on the doctrines that define and limit federal judicial power. Professor Walsh, nope, I'm not going to do all that. That's on the website. Erin Hawley is a senior legal fellow at the Independent Women's Law Center, which files briefs in interesting and contentious cases. She's been an associate professor at University of Missouri, where she taught constitutional law, among other courses. She's been in private practice, and she also worked for my former boss as well, Attorney General McCasey. So that's a nice little fun factoid. And then we have a sort of surprise mystery guest that will be joining us midway through in what I hope will be an innovation for FedSoc Telefora in the future. Josh Blackman is going to be joining us in a little while. He is not surprisingly double booked because he does a lot of these kinds of things. He's the website calls him a thought leader on constitutional law, but he's been a professor for a long time at South Texas College of Law and is an adjunct at the Cato Institute. He's written a bunch of books. He's written a bunch of law review articles, and I think you're all pretty familiar with him. So this is the sort of dream team you have to talk about severability and Article 3 power. And I think Will, Professor, you are going to give us a quick introduction to severability for those who have some cobwebs, and then jump into your views. The way we're structuring this is all of our panelists are going to talk for 5 to 7 minutes, maybe. We'll see who goes over, and then they'll lay out different perspectives on severability, and then we'll have a conversation about it. So take it away, Will.
Thank you. So the doctrine of severability has been at the center of at least 6 recent Supreme Court cases in the past 3 years. First, Murphy versus NCAA in 2018, where Congress held inseverable major federal regulation of gambling. Then Barr versus the American Association of Political Consultants in 2020, where the court severed part of a ban on robocalls from an exception to the ban on robocalls that violated the First Amendment. Then a case called Selah Law versus the Consumer Financial Protection Bureau, something with a B, where the court held that the structure of the agency was unconstitutional, but that did not invalidate everything that had been done by the head of the agency. And then in 3 cases that we've seen in the past months, California versus Texas, where the court declined to invalidate the entire Affordable Care Act as inseverable for reasons that were entangled with the doctrine of standing. United States versus Arthrex, where the court dealt with the structure of appointees to a patent quasi-court, and Collins versus Yellen, where the court dealt with another agency, the FHFA, which also had a similar structure to the CFPB. So in these 6 cases, the court has been confronting the recurring problem of what to do when part of a statute is unconstitutional. Does that mean the entire statute is unconstitutional, the entire US code? How do you disentangle the unconstitutional parts of the statute from others? And the court has purported to apply the kind of conventional black letter law, which is that when one part of the statute is invalid, the invalid part can be dropped. There's a presumption of severability, so long as the parts that are left are fully operative law, and so long as it is not evident that Congress would have not wanted those provisions to survive. There's a sort of presumption that you sever the statute, that you save the statute, and then sort of possible rebuttals to the presumption if the statute seems like it wouldn't work, or if it seems like we're really sure Congress wouldn't have wanted that. Now, this standard view has come in for a lot of different kinds of skepticism. People ask, why is it the court's job to save statutes? Shouldn't the courts just apply the law and let the chips fall where they may? Isn't saving things Congress's job, not the court's? How is the court supposed to know what Congress would have wanted to have happened? Maybe Congress left behind a severability or inseverability clause that tells us what they wanted to have happen if there was a constitutional problem, but most of the time they didn't. And so then is the court supposed to sort of imagine what Congress wanted? Is it supposed to look at, individual legislators' minds? Is it supposed to imagine what a reasonable Congress would have wanted, which is often the same thing as what the judge would have wanted, or something else? And I'd say, especially with the rise of various aspects of formalist interpretation, these pressures are increasingly strong, right? So in ordinary statutory interpretation, the orthodox view is that courts are supposed to apply the text enacted by Congress, not what Congress would have wanted, not what would be a good idea, not engage in any kind of either mind reading or policy making. And yet severability analysis seems to call upon them to engage in a combination of mind reading and policy making. So it puts the courts in a very tough spot. As a consequence of these critiques, I think several justices on the court have expressed a revisionist view, have sort of rejected this general approach to severability. They've said courts don't have a so-called writ of erasure, as Jonathan Mitchell has put it in a great article. All they should do, all they have is the sort of the negative power to just not apply the law when it's unconstitutional, and they shouldn't be making any of these kind of severability or inseverability choices. Those are a series of opinions by Justice Thomas and Justice Gorsuch, sort of each joined by the other, starting in Murphy versus NCAA. And that's where we find ourselves today. So what should we make of all this? We have a lot of time for back and forth, so I will just sneak in my views quickly. In my view, the revisionist view is correct, but it's not as simple as it seems, and it's not clear that the justices who put it forward understand their own view. So here's the right way to think about it. They're right to say courts don't have any sort of policymaking or law or mind reading powers. All they do is apply the law. Indeed, courts don't even have a general power to strike down statutes. What Marbury versus Madison tells us is that courts are just supposed to decide the case before them and apply the law that it would be constitutional to apply in that case. So if there's a statute, you apply it, unless it's trumped by a constitutional provision, in which case you don't apply it because the court can't itself be a party to a violation of the Constitution. So that's the negative power to disregard a law. Courts should just disregard things that are unconstitutional. They purport to be laws, but they're not really laws. Now, as a side effect of that, the court's duty is just to apply the law, including the Constitution when it's superior to a statute. If Congress has left behind some kind of instructions, what people might call a fallback law, what to do in case of unconstitutionality, courts should apply that too. I mean, assuming it's constitutional. So the most common forms of those are severability and inseverability clauses. If Congress says, if part of the statute is unconstitutional, here's what we want you to do, courts should apply that too. Occasionally, Congress does something more elaborate and says, if this agency structure is unconstitutional, here's our backup agency structure. Courts should apply that too. Strangely, under current doctrine, they don't do this. Under current doctrine, severability and inseverability doctrines are just sort of rules of thumb or guidelines, one more piece of evidence about what Congress might have wanted. And I think the court is starting to recognize that under sort of modern textualism, that's not right. It has to take them more seriously, and they're just law. They should be applied whatever they say. The hard part is what to do. So is where the justices struggle in the applications. So just to take a few quick examples for a few quick hits in my last minute of airtime. When confronting the Affordable Care Act, Justice Gorsuch and Justice Alito, in their dissents in California versus Texas, acted as if the Affordable Care Act contained an inseverability clause. They acted as if some part of the Affordable Care Act said, hey, if the individual mandate is unconstitutional, just let's call the whole thing off. But there isn't a clause like that in the Affordable Care Act. What there is a statutory finding that the individual mandate is essential to all of the Affordable Care Act, all of ERISA, all of federal public health law, but there's nothing like an inseverability clause or an instruction for the courts to apply. And the justices, Justice Thomas and Justice Gorsuch, have come apart in this term separation of powers cases, Arthrex and Collins, about what to do when essentially the constitutional problem comes from a combination of statutory provisions that are unconstitutional. If we say, you can't have this kind of executive power and not be removable by the president, and the statute tries to give people executive power and make them not removable by the president, what do? Do we get rid of their executive power, or do we get rid of their removability? There's no obvious answer in the orthodox view for which one of those should trump. I have my own view, but Justice Thomas and Justice Gorsuch have split about how to implement their own view, because that's a harder question that we still need to work out.
Well, thank you. That was a very helpful overview for those of us who aren't in the weeds of all of those 6 cases that you went through. So that was great to level set. Kevin, I think you're up next to share some thoughts. And
Sure.
Welcome, Professor Blackman.
I'm sorry, I was doing the Heritage Scholars and Scribes that just finished, so one to the next. I'm happy to be here.
No, we appreciate you joining us even midway through, and you're 4 minutes earlier than I expected. So thank you.
Always
So
on
that's
time.
great.
Well, great.
right.
Well, thank you, Megan, and thank you, Erin, and Will and Josh for doing this event. So the title is Severability in Article 3 Powers, and I'd actually like to pick up on the second piece of the title. Picking up, it's not a surprise that Will is a supporter of the what we might call the revisionist view. Well, I call it the old school view, or the old orthodoxy. In the Murphy versus NCAA opinion by Justice Thomas, one of the law review articles cited was one by Professor Baude called The Judgment Power. And in a nutshell, the argument is that the judicial power of the United States is the power to make judgments. That's the power of the court. And so it's to make judgments, and that's it. Now there's more. We can say those judgments might come with remedies, an injunction, do this or don't do that, or a declaration, your rights are X, Y, and Z, that kind of thing. And I think that's right. So if we think that the judicial power to change the law operates through judgments, through remedies, and then through precedent, right? So we might say res judicata, remedies, and reasons that the court gives that then are binding elsewhere in the judiciary. Those are the 3 ways that the judicial power can sort of change the law. Off of that list is any legislative change, right? So one thing that the current court agrees on, and one of the nice features of this current ferment, is that a majority of the court explicitly acknowledges that the judicial power in this thing we call judicial review is, in the words of Massachusetts versus Mellon, a 1923 case that's been cited a whole bunch lately, the negative power to disregard an unconstitutional enactment. Okay, so picking up then where Will left off, a lot of these severability cases do have a preliminary question about, well, which one do you disregard, right? When the unconstitutionality is a combination of a lot of things. Instead of saying, well, here's the right answer, you say, where do you look for an answer? I think generally you look for an answer in substantive constitutional law. So in a case where they explained in Arthrex, we're going to instruct courts to disregard the limits on review of decisions of administrative patent judges. They did that rather than give you a redo in front of different judges, because they isolated the problem to the absence of review rather than a problem with the way they were appointed. And that's just an argument about substantive constitutional law about what was wrong. So one question that I'd like to put on the table for all of us is, when do courts do severability? So an important article by Brian Lee called Situational Severability was written in the wake of NFIB versus Sebelius. And he says there's a different approach depending on when you do severability analysis. If you do it at the jurisdictional justiciability stage, at the merit stage, or at the remedy phase. I would suggest that severability is actually limited to the end of the case. And what you're trying to do is answer a question of statutory interpretation, but it's not your normal type of question where you ask, what is the law? What has been the law? What's the law that's governing this case? It's in some ways an extra question. It's, what did Congress provide about what would happen, what would be the law after a conclusion of unconstitutionality in some regard? So if we think about cases where you have explicit fallback law, where Congress says, if any of these procedures are deemed unconstitutional, here's a backup set of procedures to use, as they did in the case of Baude versus Sinar, the Graham-Rudman-Hollings Deficit Reduction Act. So we might think of the law that results from severability as a kind of judicially activated fallback law. So what the courts are doing is not changing the law, but they are making a determination. They're doing something in the world that then triggers backup law that Congress has provided. Typically, Congress doesn't provide backup law. Well, that means then there's no other law. They just do what they do and let the chips fall where they may. That would be my suggestion about timing. And hopefully later on we can discuss what implications, if that's right or if it's wrong, this has for the doctrine of standing by inseverability. But for now, I'll leave it at that.
Well, thank you. I think Erin, you're up next.
Great. Thanks so much, Megan. Thanks for having me on. So wanted to press a little bit on the revisionist sort of thoughts of severability. I think most of us on the panel are sympathetic to that, and that the judicial power is limited to this negative sort of power to disregard a statute that Will and Kevin have spoken about. That seems to be an appropriate limitation of Article 3, especially in contrast to Article 2 and the legislature's ability to make law as the Constitution provides. But I think that if you look at sort of the background of some of the cases giving rise to the severability doctrine, there's this idea that severability is itself sort of enforcing separation of powers principles because it is saving that part of the statute that Congress itself enacted. So the idea is that Congress enacted this massive statute, take Obamacare, for example, which we'll talk about a lot, I think, on this panel. And they've got this massive 900-page statute. One tiny provision is unconstitutional, or maybe lots of it is unconstitutional. But if we assume a tiny bit is unconstitutional, then should an Article 3 judge strike down the tiny provision, or should it strike down this massive 900-page statute, which is less disruptive to the Article 1 power to legislate? So I think that's some of sort of the background about why severability might be attractive to those who sort of see a limited view for judicial review. And I think in that context, it's interesting to place severability in the context of other doctrines that sort of have the same function, and to think about whether they're different or maybe they're the same and suffer from the same problems. But if we think about the rule of constitutional avoidance, and typically courts will look at constitutional avoidance, and just as Will explained, there's a presumption in favor of the severability of a statute. so too there's a presumption in favor of the constitutionality of a statute. And as most of the audience is aware, and certainly the panelists, the court has at times gone to extreme gymnastics in order to save statutes. Again, we could look at Obamacare and the different ways the court has looked at that statute. So again, there's this idea that maybe the court is being less intrusive into the role of Congress because they're saving the statute, which I think accords with sort of the more traditional or the middle term view of severability. And I think the same can arguably be said of the Chevron doctrine. Again, a very different doctrine, but the idea from the Chevron case is that courts are supposed to defer to agencies because agencies as an arm or not, arguably an arm of Congress, are vested with Congress with the ability to fill in statutes. And thus it would be contrary to the judicial role for the judiciary to sort of fill those statutes in with what it thinks the law is, rather than to defer to agencies, which Congress left in charge of filling in these gaps. That's not how I understand Chevron. I think that doctrine is extremely problematic, but I think you can see a theme in in both constitutional avoidance, the Chevron doctrine, and severability of this idea that we want courts to do less in order to leave more of what Congress wrote. And so I think that that's sort of an interesting idea of thinking about severability, which is more faithful to separation of powers principles, to leave more of what Congress wrote, or instead to, as Will said, refrain from sort of redlining or mind guessing what Congress might have wanted. So some thoughts for a conversation.
Awesome. Thank you, Erin. A lot of doctrine thrown in there. I was like, oh, Chevron, we're doing all kinds of stuff today. Great present. So Josh, last but certainly not least, and thanks again for joining us.
Thank you.
Your thoughts?
It's a pleasure. This is such a good panel where all people who I'd say are right of center don't always agree. They think this is some of the best that FedSoc has to offer. So I'm on this panel. Well, I'll talk about Obamacare. I'm sorry. In California versus Texas, I was probably the leading proponent of the so-called standing through severability, and I got my butt kicked. So I can live with that. But I just want to explain why I thought this theory might work. And when you don't even get Clarence Thomas's vote, you just got to hang him up. The theory was simple. The mandate was unconstitutional. Obamacare told us that, right? And as I read the statute, the mandate was inseverable from other provisions. Now, I know the Congress and this and the Congress and that, but just in the abstract, I thought that if we assume that the mandate is inseverable from the other provisions, there's an injury, and you can enjoin the enforcement of those other provisions, so you get redressability and traceability, you get Article 3 standing. The majority in California v. Texas ignored that argument. They said it was waived. It wasn't waived. I mean, I live this litigation. I have a book I'm writing a book about it. This argument was raised below, but whatever. The majority didn't want to touch it. Justice Alito in his dissent said it was a novel argument. He didn't want to touch it either. Justice Thomas, though, had a footnote. And oh man, that footnote. He said, assuming it's even a theory, which is like Thomas' way of saying, yeah, no way, Josh, sorry. So I think Justice Thomas has made clear that this sort of linkage between standing and severability occurs only at the remedial phase and not at the entry level phase. During the oral arguments, though, there was a good colloquy between Don Verrilli and I think it was Justice Alito, where they were discussing this. And Alito said, what if you had a provision, a statute with three aspects? One of them actually inflicts an injury, and then a second provision has an obvious racial discrimination, right? And these provisions are inseverable. You can't separate them. But the racial segregation provision doesn't inflict an injury. And Alito asked Verrilli, would that get you to federal court? And Verrilli said something like, that stretches the limits of our theory, basically saying, yeah, that would work. So I think there might be a case where standing to severability works, but Thomas has poo-pooed it. And I think Justice Thomas is definitely the most interesting man. He's the most interesting justice by a mile. He is such a thinker. And I think his position on severability changed from last year in Seal Law to this year in Collins and Arthrex. And maybe Kevin and Will and Erin can correct me, because there was one point where Gorsuch said, Thomas, last year you said this is how we're going to do it, and now you're saying something different. And then Thomas says, well, maybe I am. So I think we've even seen a shift from 2020 to maybe the pandemic gave some time to think, right? But from 2020 to 21, I think CT has evolved. And his position in Collins is absolutely fascinating. I hope we have time to talk about it. Is John Harrison? No, I don't see John Harrison's name. John Harrison put in an amicus brief, which I found fascinating, where Harrison had this sort of existential question. If a revision is unconstitutional, it's like it never existed. It's like Schrodinger's statute, right? If it's unconstitutional, it's never actually in the statute. Therefore, there's nothing to sever. And if you read Thomas carefully in Collins, he seems to be saying that there was no for-cause protection because it could never be enforced. It was an unconstitutional restriction. If Thomas is right, almost everything we know about severability and remedies are just helter-skelter. Let me make one final point. So far, there have been consistently 5 or 6 votes to rule in favor of the conservative cause. But in a future case, if Thomas does his thing and the liberals peel off a vote or two, that could flip the case. So actually, the Thomas idiosyncratic approach of standing and severability could actually result in judgments against the sort of right side of the case, again, which is why he's the most interesting justice. He just thinks things through. He says things, and then law professors like the 4 of us have to start thinking about it and rewriting everything we know. So I'll leave it there. I think we have a lot of time for Q&A. And again, I'm so happy to be here with Erin, Kevin, and Will, and Megan. Just such an august panel. Thank you so much.
Well, thanks for joining us. And to pick up on that last thread, I found myself wondering what the right or conservative side was that you're referring to. And that leads me to my first question, because I can't help but think, and I hope you don't think I'm channeling sort of cynicism here, but is there really a principled approach to severability at this point? I mean, it feels, and I think certainly probably feels to anyone looking at some of these decisions, that severability decisions or analysis may be reverse engineered to either avoid hard questions or avoid unintended consequences, and that may be why it's a little fluid in its actual doctrinal components and application. But to get us going, do you think there is a principled approach to severability right now that's not just outcome determinant? And I'm not going to pick on one of you. I'm going to leave whoever wants to just jump in. But if you don't, I will pick on one of you.
I'll say yes. I think actually the reason it's so fluid is sometimes these when cases are doing this kind of thing, we smell politics and we're right to smell politics. I don't think that's what's going on here. I think what's going on is severability is really hard, and our intuitions are inadequate because we have an intuition that judges shouldn't be doing judicial lawmaking. And both of the natural things to do in severability actually kind of feel like judicial lawmaking. So throwing the entire statute out because of one tiny flaw that comes up in a case feels like an aggressive act of judicial lawmaking. But doing anything else, picking and choosing parts of the statute, so you're throwing out only part of the statute, results in like a half statute that Congress didn't enact. And that also feels like judicial lawmaking. But I don't think that means there's no principled approach. I mean, I think that Justice Thomas and Justice Gorsuch are onto something. I just think it's, in a way, it's like calculus. There's a certain level of math we can do in our heads, and then sometimes you get to like the harder it's a problem that just turns out there's like an advanced level of science you need to solve the problems. You don't need them in most cases, but every once in a while you have to call your college math professor.
Which is frustrating because when you actually lay out the elements of the severability presumption, it's deceptively simple, right? Like the two ways. So any other thoughts on sort of reactions to Will, or is there a principled approach?
Yeah,
Kevin?
I'll go. I think severability doctrine has the advantage of a nice name, and everybody thinks we need it. And the name though is misleading because as the court recognizes, and as we've I think recognize, that severing is not something that they do. It's not a thing. In some ways, it's a question of what follows from this judgment, whether on the revisionist view or not. When they say that something is inseverable and therefore entirely unenforceable, if you go the next day and look in the U.S. code, the words are still there, right? And so it's more just what kind of effect are they giving. So the principled approach, I think, is to say, what business do we have doing anything other than sort of declaring the law that is necessary for this particular case? Inseverability is almost never necessary. And sort of reaching that question is almost never necessary. And what's weird about I'd say the unreformed view is, having recognized the metaphorical nature of severance or excision, they nevertheless projected backwards, saying as if this has existed for all time. So Justice Kavanaugh's opinion for plurality in the Barr case said, look, John Marshall did it in Marbury versus Madison. And it's like, no, he did not. Do not blame John Marshall, because, and he didn't wring his hands about, after we've decided that the Supreme Court lacks jurisdiction to issue mandamus in the exercise of its original jurisdiction, he didn't say, oh gosh, if only our Oliver Ellsworth had drafted this thing, I would know, whether the rest of it needs to fall, right? So I guess, to me, I'd say, is there any principled approach to doing anything other, right? To then sort of letting the chips fall where they may as a matter of constitutional law. And people call that a presumption of severability, but that assumes that you need to do something in order to contain the case. But that something usually happens on the front end with justiciability doctrine that says what you are allowed to complain about and what they are allowed to redress.
So Josh, you were shaking your head very vociferously there, but I think
I agree. Yeah, we can blame John Marshall for a lot of things, but severability is not one of them. I mean, look, I'll give you the example, the one that ticks me off about severability, which is Whole Women's Health, right? This was the abortion case from a couple of years ago. And then Texas passed this law requiring certain surgical standards for abortion clinics. But there was one provision that required smoke detectors, right? That abortion clinics had to have smoke detectors installed. And Justice Breyer says, with a flick of wrist, well, we can't sever that provision, so we're going to strike it down. Come on, a smoke detector then poses an undue burden on abortion? It just strikes me as surreal that you have a statute that requires installation of a smoke detector, and that has to go because there's an undue burden on abortion, that a $5 smoke. Anyway, so that is the case with left versus right. I think both sides abuse in any given case, which I'm grateful that Justice Thomas and Gorsuch are bringing some intellectual rigor to this discipline, because at least as it was in Whole Women's Health, it was bizarre, incoherent.
So I wanted to take us in the direction of sort of the tactics of severability, right? So I was reading some commentators who've referred to this atomistic approach, where in many cases, they've been focused on these individual remaining provisions, and they've gotten sort of pointillistic or atomistic, as opposed to the function of the whole statute. And this commentator was saying, by focusing on these individual provisions, you can minimize the impact of non-enforcement. And maybe that is, to what Erin was saying, more respectful of the legislature. I think there's really interesting questions we can get into later about what really is most respectful of Article 1. But is this so-called atomistic approach, do you think, more or less respectful of the legislature?
Yes, maybe I'll just start us off on this one, perhaps, if that's all right. The atomistic approach, or the sort of provision by provision approach, does seem to me to be a function of justiciability doctrine, in that, especially after California versus Texas, right? Which, as Josh says, they didn't formally address standing through inseverability, but I think that the approach to standing that is there is sort of funnels statutory provisions that they can then start from. And I think this is important because it's sort of counterintuitive, but the severability test, at least as currently formulated, is asymmetrical. That is, it depends which one you start with. So take the Affordable Care Act. The question in severability is, if this provision is no longer enforceable, let's skip the first part. Can it operate as law? The rest operate as law. And we say, would Congress have preferred what is left? If you pull the individual mandate out, there's one answer perhaps to that question. But then take something, like the employer mandate, right? It may be that the thing can work with one and not with the other, depending on which one you say, can you do without this? Or what would Congress have preferred without X? It matters what X is. And then what California versus Texas does is say, here's the rules about what you need to do to challenge X. You need to go for you need to show concrete injury traceable to the allegedly unlawful conduct of enforcing that X, right? There might be Y, and you say Y should fall if X falls. But you have to show first the conduct of X affects you. So I think whether or not it's more respectful of the legislature, I think we're stuck, and I think it's a good thing with this sort of funneling that happens from justiciability, if that makes sense.
Yeah, that makes sense. Any reactions to that?
I guess I'd add, I think it's most respectful of the text to treat the text in this kind of atomistic fashion, because there are a bunch of textual provisions and you just deal with the ones you have to and leave the other ones alone. And then the question is there something else? Is there like a legislative will or a legislative purpose outside of the text? If you think there is such a thing, then maybe the courts should be more respectful to it and use that broader legislative purpose as a tool of statutory interpretation. But if you think there isn't such a thing or courts can't find it, there's nothing to respect.
I mean, doesn't that then sort of go towards the second part of the test or the presumption, which is, you put the text on one side and you look and see, does the statute make sense? Does the statute function? But I feel like much of the discomfort with some of the severability analysis shows up at the back end, or the second piece of it, when you're sort of speculating about, would Congress have enacted this, or would the state legislature have done this? And that's where I think my own discomfort comes, which is you're sort of reading tea leaves, you're elevating legislative history. But is that kind of the rub here, that we're sort of getting away from that latter part that maybe we've been more uncomfortable with?
I think so. And I think this is where it's not just Justice Thomas and Justice Gorsuch. So Justice Kavanaugh, in his plurality opinion in Barr versus AAPC, was dealing with the severability problem. He described this kind of like the back end, what would Congress have done question. And he said, this is our test, but experience shows that this formulation often leads to an analytical dead end. That is because courts are not well equipped to imaginatively reconstruct a prior Congress's hypothetical intent. Absent a severability or non-severability clause, a court cannot really know what two houses of Congress and the president would have wanted if one provision were later unconstitutional. I think that's the rub.
Yeah, because there does seem to be some artificiality about that, which is there's the realpolitik of what could they have achieved without this clause, which maybe is different than what they really wanted to happen, right? And I think you see that in a bunch of these different cases. My firm does a lot of the technical sort of robocalling stuff. So we watch that with no small degree of horror, thinking, oh, the whole thing might go down. And then like, which in certain respects might be sort of funny, but is also sort of terrifying as a policy matter. And I have no doubt that the justices had the same thing in the back of their minds, that we will not be the ones who unleash a wave of robocalls on America. So I have to think that colored their views.
Can we ask you a question, Megan?
Oh God!
Which,
I didn't sign up for that.
Well, so on Barr, right? I mean, so you have this weird thing. Imagine it never got to the Supreme Court, right? And so you have this a law that says no robocalls to cell phones. We're paraphrasing, and it's totally fine. And then again, paraphrasing, no robocalls to cell phones unless you're collecting government-backed debts, right? And that's 2015. And so Congress unleashed a wave of robocalls. It's debt collectors. Okay, fine. And then people want to unleash another wave, the politicians. And so they go to court. And so they lose, right? They win. Well, do they win or lose? They win and says, yep, the law is unconstitutional, but we're going to snip out that exception. So it would seem to me that the people who were unleashed in the first wave, the ones unleashed by Congress, would have been kind of in trouble. And yet, if they weren't in, say, the Fourth Circuit or whatever was governed by that, what do people advise clients? And perhaps you can't ask since it's about client advice, but isn't there a problem with severing an exception by sort of broadening the scope of criminal and civil liability? And what does that even mean?
No, I think it's super interesting to think about how the consequences of these things play out. I was listening Sarah Isger and David French, I was boning up on severability by listening to their podcast, and they keyed in on this exact case. And they said the perverse result is, as a result, less speech, right? So when you think about what it would have meant to strike down the statute, I think maybe Congress would have been in trouble, because by creating the exception, they sort of Swiss cheese to the statute. I think, when it comes to advising clients, lots of people were watching the severability analysis, because obviously there's bigger cases at stake than the robocalling case. It was kind of a bellwether, perhaps people thought, for other cases. But I think there, Congress, this is where I'll turn it back to you guys. Is severability sort of taking Congress off the hook, when maybe the cleaner and more respectful thing to do to the Article 1 power as a limitation, right, is to send stuff back to Congress and say, you blew it, right? You can't create an exception that patently violates the First Amendment. Start over. Don't go down this path and then have us fix it for you by playing games with severability.
Yeah, this was basically the approach in the Obamacare case with the Scalia, Thomas, Kennedy, and Alito joint opinion. It's like, we don't know what Congress would have done, so just start from scratch. We'll send it back to the drawing board. Of course, that presumed the political will is there. Obamacare was passed in a very unique moment in American history with 60 votes in the Senate. By the time 2012 rolls around, this was not a popular statute. So again, this gets back into realpolitik. Congress won't reenact this thing. Oh yeah, Congress, go fix it. It's like saying, haha, you won't do anything. It's gone. So it's this sort of trap.
Yeah, and the thing is, if Congress knew what they wanted, they would either do it, they would fix it. I mean, nothing stops them from fixing it, even if there's a severability holding, or they would have told us in the first place. They would have enacted a severability or inseverability clause. So in a way, when Congress has made clear, like, we're not going to clean up the mess, I'm not sure it's respectful to like take the mess and show their face in it and say, well, you have to clean it up.
I don't know. It sort of feels though like we're then, well, maybe not we. It sort of feels then like the judiciary would be sort of acquiescing to the dysfunction and acquiescing to sort of that throw your hands up, Congress won't do anything. So we need to then tinker around to make sure things survive, which kind of raises the next question I was going to ask you guys, which is, given the apparent dysfunction in Congress, should the courts treat severability as a way to respect a Congress that can't often get together to legislate, right? Stuff that comes out right now is few and far between. How should that impact how we think about severability or how the judges think about it? Because I'm torn about what's more respectful, to sort of impose upon them some discipline to say, sorry, go back. Sorry, you're dysfunctional. And we know politics has changed, but try again. That feels potentially quite respectful of the Article 1 role to be the givers of law, notwithstanding their own dysfunction. So, I mean, does it matter, just to summarize, should we care, or should it factor in that Congress is dysfunctional, as opposed to take as a given, like, how it should work when a judge is thinking about severability and the consequences of failing to sever, for example?
I guess as sort of a high-level principled matter, I'd argue that it shouldn't matter, that the judicial role shouldn't be dependent upon how well Congress is participating in its own constitutionally given role. So just because Congress doesn't do anything. I think that's the same argument that's made in favor of allowing administrative agencies to have a really broad brush in the sorts of regulations that they issue and in the sorts of regulations that they get deference to. So the argument is Congress isn't capable of doing it, therefore we should let the agencies. So I guess my view, even though certainly there's a lot of dysfunction, is that doesn't itself change the Article 3 role of the judiciary.
So I think I agree. I think what it does is it just makes the downsides of formalism more apparent. I think they're worth it, but it's the same problem in textualism, right? Is it's tempting to defend all the absurd results in textualism by saying, well, don't worry, if it's an absurd result, obviously Congress will fix it. And then we learn sometimes that's not true. That doesn't make textualism false. It doesn't mean courts should fix absurd results, but it does mean then you have to swallow the, like, yes, sometimes there'll be an absurd result and nobody will fix it. And like, that's because we have a dysfunctional Congress and it's not our fault. And that's sort of, I think now the courts are just being given these kind of incomplete, rickety statutes that don't totally address the problems we wish they addressed. And they have two choices. They can wish or pretend we have a better Congress than we do and go back to them and say, your term paper's not finished, like, do a better job. Or they can just do their best to apply whatever we've got, even if it's kind of a hash.
I mean, we do know, right? Congress is not oblivious to judicial doctrines, right? They're hip to severability. They write statutes sometimes with an eye towards it. Sometimes there's strategy there where they're going to kick something to the courts and sort of cross their fingers and hope it's fixed or ignored. But how do you guys think judges should approach severability and non-severability clauses? That's something that was a couple of you alluded to. There have been times in private practice where I've wished there was a severability clause or a non-severability clause, depending on what outcome we wanted. But how should judges think about that, and what unique problems or opportunities do they present?
So I'm kind of on Will with this one. If the whole point of severability is to determine what it is that Congress enacted, then when they tell you what they want to happen, then it seems like the judiciary should follow that. So it seems like both the principle of textualism and then also consistent with Article 3 and Article 1 powers.
Yeah, I think they should approach them with great relief. Here's this hard problem. Now Congress has solved it for us. The downsides, as far as I can tell, are that Congress does not actually do a very good job writing severability or inseverability clauses. So severability clauses are much more common than inseverability clauses. Congress almost never does anything other than say, oh yeah, sure, the whole statute's severable, which is already kind of the default rule anyway. So it's not a super useful instruction. And then the severability clauses don't usually answer the questions courts actually have to resolve. Like, okay, suppose that, various provisions of this agency are severable. Which ones do you want to go if we have to get rid of one, but not all? And, it would be great if Congress would, get hip to that problem and say, when in doubt, the enforcement authority is the most important thing. We don't care so much about the removal restrictions. Or the opposite, say, if this guy can't be insulated from political pressure, we don't want him at all. Those are like the basic top level questions that courts could really use guidance on, and there's zero chance they'll get it.
I'll say a few words about inseverability clauses, Obamacare. During the 2012 litigation, the Obama administration argued that the findings were an inseverability clause. Now the same lawyer said, no, never mind, they're not really inseverability clauses anymore. So I think Erin and Will are on point. Even when Congress drafts them, they're not always very good. But I think inseverability clauses are quite rare. I'll direct your attention to a state law on inseverability, which is involving Texas, the Texas fetal heartbeat law. If you want to see the most intricate severability clause ever, read the Texas fetal heartbeat law. It's like 5 pages long, and it goes through every permutation of possible events. It's written in a brilliant fashion. I can't even describe it. Just read it. It's SB8. It's fantastic. And eventually some court will have to consider it. And I don't see how they can do anything but the most narrow thing possible. It tries to take every possible pain to limit damage. So maybe Congress takes some lessons from Texas.
A couple observations on these clauses. I think the right way to approach them really does depend on the default, because that's why I hesitate to attribute too much significance to a severability clause, because what happens in the more common case when there's neither? And then if the idea is, look, this ruling displaces that aspect of the law, and that's that. Right? We don't need any more clauses. We're kind of done. We don't say, okay, what should we do with everything else? We're just finished. Then we don't need a severability clause. And then the thing is, what about an inseverability clause? And so Josh raised the findings in the Affordable Care Act, and we have a question about the findings as well in our Q&A. And that's the thing is, what does an inseverability clause look like, right? Is it, if severability is about contingency legislation, sort of fallback legislation, right? In the event that this thing happens, where this thing is a judicial finding by a court of competent jurisdiction, a final court, whatever, you got to figure out what your trigger is. But if this thing happens, then the law shall be Y instead of X. That is a classic inseverability clause. A finding that says, look, we really, really need X in order to get Y. That doesn't sound like an inseverability clause if we're limiting the severability to fallback law. And so now the reason that this classification matters, or among the reasons it can matter, is questions of prospectivity and retroactivity. So if the law was X, until this thing happened, and then it became Y, right? Well, that matters for everyone who is subject to X and prospectively subject to Y, right? So if the law, though, was always Y because X was always unconstitutional, well, then what about people who have done things that are subject to liability under that new law, right? Because it turns out that new law was the law all along. And this kind of brings us then back to Josh's point about Justice Thomas's opinion, and where Justice Thomas said, well, if this law is unconstitutional, then it was never the law. So maybe that depends if the unconstitutionality inheres in the law itself or in some of its applications. So a lot of times, when we say a provision is unconstitutional, that's shorthand for saying it may never be validly enforced consistent with the Constitution. So we want to know, is this constitutional test that by which something is invalid, is it sort of an existence condition for the law, or is it an application condition? Now, situations where it's unconstitutional in all its applications, like this structural provision, we may say, hey, there's no big difference there. Right? But something like the unconstitutional application of a state long arm statute, right? Or the unconstitutional application of a certain search technique that's authorized pursuant to some policy or something like that. So I want to be careful and think, as Josh said, when Justice Thomas writes, we want to think carefully about what he says. That's something I want to think more carefully about before saying, yeah, I definitely agree with that. Because a lot of times what we mean by an unconstitutional provision means an unconstitutional application or set of applications rather than the provision.
And here's
Go ahead, Will.
As we can take a little bit of wisdom from the John Marshall era too. So Erin mentioned the canon of constitutional avoidance. Back in the day, the courts didn't really distinguish as much between severability problems, constitutional avoidance problems, and judicial review generally. So they would commonly have a broadly worded statute that would be unconstitutional if taken literally in some applications. That is, and they would just say, well, this statute can't possibly authorize thing X because thing X would be unconstitutional. So they would have, like a broadly written criminal law, and they just say, well, the law can't be applied to do X, where X would be unconstitutional. And they wouldn't really clearly spell out where they. Now we would say it matters a lot. Are they finding the statute unconstitutional and then severing the applications, or are they saying that the statute will be interpreted and the canon of constitutional avoidance not to be unconstitutional, in which case it has to be ambiguous? They didn't do it. They just said, in this case, we can't make the statute do X because X would be unconstitutional. And they didn't have this sort of modern machinery. So that's part of, I think, where Kevin is coming from as well, and saying, like, maybe courts shouldn't even be asking these kind of severability questions. They should just be asking, can we do X or not?
If I could just jump right in real quick on the Marshall stuff. And so take a case that everyone at least was once familiar with, Gibbons versus Ogden, right? So as we know, that was a preemption decision ultimately, right? That's what we call it. But if you think about the logic of that opinion, Daniel Webster has this great windup, right? And he tried to take credit for something else. But his big argument was that the New York monopoly on steamboats, right? So everyone remembers this. It was no good because the power to regulate commerce is exclusive. That was his kind of big thing. And then Marshall says, well, we're not sure that's wrong. In fact, we think there's a lot of force to that, but we don't have to decide because there's an actual conflict between the license holder under this federal coasting law, right? So in this case, so that would be clearly an example of sort of as applied sort of adjudication where the person, so a lot of times, even though they don't have the categories that we have right now, they don't say facial versus as applied, we can often look at their reasoning and say, yeah, they had one test that would make this totally bad and one that would be just in this application. So in some ways, we have new vocabulary and some new concepts, but some of these problems are sort of perennial.
Yeah, the facial versus as applied rabbit hole, as I recall, can get a little heady. So I'm going to leave that to you guys, although there is some appeal to saying severability should only be applied when, in a maybe a narrower set of challenges where you're looking to really, I don't know if there's an overlap here with national injunctions, and sort of we can go down that doctrinal rabbit hole as well. But super interesting. There is a question in the chat that actually is the flip side of a question I was going to ask in a few moments. The question came in: should federal courts apply the same severability principles in challenges to state statutes as when they're considering the viability and validity of federal statutes? I was going to ask a slightly different permutation on the state question here, but let's go with the question in the chat. Is there a different set of equities, concerns, respectfulness that should affect severability when a federal court's looking at a state statute?
I don't know. I mentioned the Texas fetal heartbeat statute, which again relies primarily on federal decisions. I haven't given much thought to whether there should be different standards. I don't know, Will. I think I interrupted you. I'm sorry. Did you have a thought?
Well, yes, there is a general literature and dispute about when federal courts are interpreting state statutes in general, to what extent should they use state interpretive principles? And under the logic of cases like Erie, they probably should, but in practice they don't, because they learn statutory interpretation in law school and aren't going to go like relearn it for every new state they confront. I think the right answer would be the judicial power doesn't change based on what courts are doing. So courts still only have the power to apply the law and then to not apply law that they can't legally apply. So the sort of effectively presumption of severability would stay the same. But the possible fallback law could change a lot, right? So we're used to, at the federal level, we know there's no federal common law, so there's no source of federal common law fallback authority, and we look for state severability clauses. A lot of states do have legislative fallback provisions in severability, and they could have common law sort of fallback law and severability. So I think at that stage, when the federal court is asking, okay, this provision can't be applied, is there any sort of fallback law? There could be state fallback law, and that'll be hard for them, and they might have to certify it or otherwise deal with it. They should not do what the court did in Hellerstedt, where they said, we refuse to apply a state severability clause because that would deprive plaintiffs of their constitutional right to bring a facial challenge, which is confused.
Very good. So Len, I want to kind of talk about litigating severability. You mentioned earlier, I think it was Josh, who was talking about congressional incentives with respect to severability and inseverability clauses. And if they, maybe in an ideal world, they would tell judges what are the most important pieces of their legislation and what should hit the cutting room floor if they have a problem, and what's really, really critical, so take down the whole statute. But litigants informing their cases also have to grapple with severability. The stakes are serious. You don't want to necessarily tell the judge that, like, hey, we think this parts of the statute that we're challenging are actually okay, so save those. I was curious for your guys' reactions to DOJ's submission in February this year in California versus Texas that reversed its position on severability, and sort of, what do you think the court did and should have made of that? I know they didn't end up grappling with that question, but in terms of this strategy of how much does the severability discussion, when we challenged a state lawsuit, we pled severability at the outset because we thought we had that burden in that court. But curious for your thoughts on sort of the strategy here, and in particular, the DOJ reversal of position, but any other aspects of sort of litigation strategy for those of you who've litigated these cases or, watched them be litigated.
I think that's my question. Sorry. Look, I think that the DOJ position was not as radical as the press made it seem. They weren't calling on the entire statute to go. They were simply following Thomas's lead in Murphy. What they didn't know, what I didn't know, was that Thomas only applied that at the remedial phase, not the standing phase. So in other words, you have severability through standing, but not standing through severability, right? You can go backwards, but not forwards. And I think that was the issue DOJ made. The Biden decision to flip it was not surprising. I suspect that there was a lot of pressure on them to do that. And ultimately, the court said, we don't care because it's waived, and that was gone. But this will arise in other situations that are not Obamacare, they're not contentious. And I think some judge somewhere may decide to pick up on it, notwithstanding the Clarence Thomas footnote saying this is not a real thing.
Anyone else? So related to that, then, private litigants crave predictability, right? Not everyone is just thinking very important constitutional principles here. So putting aside hotly political cases, I mean, in your view, how should litigants think favorably about severability in order to preserve their regulatory regimes, right? From regulated entities, you might agree that the method of appointing commissioners is unconstitutional, but after 10 years of living under regime, you might not want that regime to go away. So any thoughts on sort of how litigants should be thinking about use of severability?
A couple of thoughts here. One is don't rely on inseverability for some of the reasons that Josh mentioned, right? So make sure that you can say for the things that you want to go, make sure you can say how they've hurt you, that like the thing that you say is unlawful, not what follows from it, right? And there's a certain logic to no standing through inseverability, which is that it's the judicial power and to say what the law is, not what the law would be after they say what the law is, as to something over there. The second thing, though, is apart from the pleading, and we see this in Collins versus Yellen, right? So this is the case involving the Federal Housing Finance Authority and unwinding a sort of a deal that the government essentially made with itself that hurt Fannie Mae and Freddie Mac. Now the deal, apparently it was called the Third Amendment. The Fourth Amendment is now there. So they're not worried prospectively, but they remanded, the Supreme Court did, to say, look, we're, as a matter of law, you're not entitled to unwinding this deal because this acting director initiated it, okay? But we're going to let you try to make a case as to how the carrying out of the payments and other things in accordance with this deal from the acting director may have been affected by the acting director's perception of not being subject to presidential removal at will. So it's going to be this incredibly fact-intensive, or according to Justice Kagan, it's already been decided because presidential authority was sort of interwoven throughout. But the point is that at least after this current term, when you're saying that you're affected by a provision that is unconstitutional, that has not been directly applied to you, but might structure the agency, say that is doing something to you, try and build your case and think about factually how you would show that particular feature, right, affected you in fact. Right. So unless the person was unconstitutionally appointed or the board was unconstitutionally appointed, in which case you're going to get a do-over in front of a new group. That's a case called Lucia. Unless they were unconstitutionally appointed, you may end up having to do this fact-intensive thing. And so, from the very beginning of the case, you want to think, well, what if we win, but only this much? How can we show that there was a factual connection? And that may frame, questions you ask and things you highlight from the very beginning.
I guess one other thought is that it may be worth getting out in front of it. So these severability questions seem to depend in part on how the case that the court gets before it is framed. So if the court gets a case where the victim is a victim enforcement authority, they'll look at it through that lens in a way that they'd look at it differently if it's a person who's been fired, or in a way they'd look at it differently if it's a person who has a challenge that's other part of the statute. Or in Bar, which we talked about briefly, it was a declaratory judgment by some entities who wanted to engage in robocalls. If they had brought this as a defense in a criminal action, it might have looked a little different. It's even harder to say, well, we're going to punish you because even though the statute is unconstitutional, we've decided to also punish some other people as well. So thinking through the exact best posture for the courts to hit this case, maybe especially important in strategizing how you want it to go.
Erin or Josh, anything on that? So we do have some questions in the chat about Bar. And I love that people are so interested in the robocalling case. But a couple different ones, and I'm going to throw them to Will. I'm not going to read them to you, but the first one is kind of about sort of prospective versus retrospective, and how that works when you're severing, and sort of what would happen to people who, had maybe conduct that was, illegal under or permitted under perhaps the prior version of the statute before you've engaged in the severability analysis.
Yeah, so this is great. So In Barr, when the court concludes that they're going to disregard the exception and they're going to now apply a flat robocall ban, the plurality opinion of Justice Kavanaugh does recognize this is going to be especially awkward for people who were collecting government-backed debt via robocalls until the Supreme Court decision, who, as a consequence of a First Amendment lawsuit, have suddenly found their speech criminalized, which seems a little ironic. So he says in a footnote, well, we're not going to do that. For reasons that the court doesn't explain, we're confident this will not be applied retroactively, and indeed, people will have until the date of the final entry of judgment in this case before they could be held liable, so there's no retroactive liability. The thing is, it's not at all clear where the court got that. The court actually spent decades experimenting with this problem of like when it decides cases, are its decisions retroactive or should it sort of carve out exceptions for people who acted before the case decided? And it was a mess. And they eventually said, no, we can't really do this kind of prospectivity thing because it's a form of judicial lawmaking and also it leads to all sorts of weird line drawing problems. And the footnote doesn't really explain where any of this comes from. And in a recent district court opinion decided by Third Circuit Judge Stefanos Bibas, sitting, I guess, by designation on the district court, he concluded that the plurality was wrong and that actually there was retroactive liability because, so it's just a plurality opinion, so it's not, binding, and that there were no, cases that supported the majority's own conclusion that its decision or the plurality's decision that it's shouldn't apply retroactively. Now, I've got to imagine that will go back to the Supreme Court and they may well try to come up with some way out of it. But this does thrust them into a new world. So right now, there are also a lot of lawsuits about retroactivity in the union context, as all the public sector unions that were collecting agency fees until Janus suddenly realized that they could be held liable for huge sums of money. And the lower courts have been struggling to find ways to get the unions out of liability. And it's not clear they have a legal basis to do that either. So I do think we have a new day of reckoning for, is there some sort of anti-retroactivity doctrine the court's going to have to invent?
And do you think that would be broader than related to severability? I feel like now we're sort of stacking first, second, third, fourth order problems on top of each other.
Yeah, no, I think in some ways it is a broader problem. That's the scary thing about severability is in an attempt to solve the severability problem, the court wandered into an even bigger problem potentially. What lower courts have done is create a kind of quasi-qualified immunity doctrine called the good faith doctrine. That's like qualified immunity, but weaker for people who acted in reliance on decisions that have since been overturned. This is all the questions we ask about qualified immunity, like where does this come from? How do we decide what counts as good faith? And there are precedents suggesting courts shouldn't do that. So it may get even more complicated.
The prospectivity, retroactivity thing, and there's another question about sort of under-inclusive laws and kind of that we can sort of open up into. And this is why I think that if we understand severability as fallback law, that is not judicially created, but judicially activated, such that the law actually changes, not through the judicial decision, but as a result of it, right? And result of it followed by Congress's directive that this is what we would have wanted, okay? And by the way, if the First Amendment test in Barr was one that says, yeah, this may not be applied in any circumstances because it's a content-based restriction on speech. Now, normally that we understand those as problems with the rules rather than the application. But if we don't think it goes to the very existence, in other words, once Congress said there shall be an exception for robocallers collecting government-backed debts, that became the law. And then it stopped being the law as a result of severability doctrine, which itself is a contingency, right? Then it didn't stop being the law, contra, say, Judge Bibas, right? Until the trigger was pulled by the judges in Barr. Now that is a bunch of epicycles, but it is worth preserving, right? The sort of idea that judges find the law and don't make it. So it is one way of saving that. Now, the thing that's weird about Barr is mostly as a matter of First Amendment law, because as one of the questions points out, there are other cases that could have been solved in a similar fashion, right? So we have one set of speech rules, and then we make an exception for somebody else, or the billboards where on-premise versus off-premises is a good one. There's others that are throughout speech law, and normally, just as a matter of First Amendment law, the person who shows that they are being subject to a content-based or viewpoint-based law that fails strict scrutiny, usually they win. right? And if you go back to the cases where that generated this back in the 70s, this is how it works. So Mosley is a case. Another case is called Granite versus Rockford, where you had a law that said no protests outside of schools. Okay, I'm simplifying, but except for peaceful labor demonstrations. Okay, so it turns out that that's no good because of the exception. And they said, so these people who were prosecuted under this ordinance, even though they weren't engaged in peaceful labor demonstrations, hey, they were subject to an unconstitutional law. We see, by the way, that they've changed the law and fixed it after they prosecute these people. That doesn't change anything because they were subject to an unconstitutional law. So Barr, we might think of it as a severability issue, but we might just say, if you had applied your normal First Amendment doctrine, this is how it should have come out, which, though, by the way, is important when you do the vote counting in Barr. The First Amendment analysis also does not get a court. So 4 justices, Kavanaugh, Alito, Roberts, Thomas, say strict scrutiny, and Gorsuch also says strict scrutiny, but for other reasons. And that's because as a matter of his constitutional test, Gorsuch would have said you can't sever anyhow. Don't blame severability if it might be a problem with sort of inconsistency with prior substantive law.
Any reactions to that? Anyone to follow up?
Well, I'll say, I do think Kevin is right, and this is another substantive sort of non-severability topic this brings in, is in some ways, these severability cases like Barr highlight some of the weird things about First Amendment doctrine in the first place. I mean, I love free speech. I'm always happy to see it protected, but the doctrine has become somewhat obsessively focused on kind of formal questions of neutrality, like, are you being treated exactly like other people? When, neutrality is really just a proxy for the underlying question we really care about, just like, is the government suppressing speech without adequate justification? And as the doctrine has become sort of more formalistic and more obsessed with neutrality, it's part of what thrusts us into these weird over-inclusive, under-inclusive things. Because it's a little weird to say, it was totally fine, it didn't violate your free speech rights at all, to ban robocalls for 20 years, even though nobody could do it. It was not a free speech problem at all. But now, because a few debt collectors get to do robocalls after all, suddenly your free speech rights are violated. I mean, like, I kind of get it as a matter of doctrine. I kind of get how we say, well, look, if the government's willing to make an exception for you, it should make an exception for other people, et cetera, et cetera. But just like a stepping back in terms of what's happening to speech. So it's a little weird that we say it's totally fine to suppress massive amounts of speech as long as you suppress it really broadly. And then, the one exception creates this whole thing. So that's the nicest thing I've ever said about Justice Breyer.
Well, the First Amendment issues in the robocalling context are super interesting and the product of decades of litigation, some of which I think would come out differently if it were being done today. So that's maybe a teleforum for another time. I was going to take us in the direction of sort of administrative agencies and regulatory uses of severability. Are there any other questions in the chat that someone sort of wants to jump on? We did get one question that I think is a little sort of big picture, which is, to take us back to Blackman's sort of Affordable Care Act odyssey. Someone asked, do you see any possibility that the law would ever will eventually be ruled unconstitutional in a future case? Josh, do you have a view on that? I don't want to ask you to sort of give up the ghost on that, but we're really in the final gasps here for these cases.
The Obamacare odyssey, the Obamacare trilogy, whatever you want to call it, we ain't over. The court did not resolve the issue. At some point, there'll be another case. My best guess is a qui tam action. Someone somewhere in the Fifth Circuit will be accused of fraud under the ACA. They will raise as a defense, you can't charge me with fraud because the entire statute is unconstitutional. In that sort of affirmative posture, there's no Article 3 issue. It's a case brought by the government, and you can raise whatever defense you want. Now, the mandate doesn't operate on the individual in the same sense they did in the ACA litigation. But a court, I think, would have to adjudicate, is this in fact inseverable? Because there's no standing inquiry. The court might find, yes, the mandate's unconstitutional, but everything else is fine. And I think under Fifth Circuit precedent, that's probably the result you'd have to reach. But this will be litigated. I wish this were over. I wish the court just killed this case like a putting a wounded horse out of its misery just saved me the hassle of having to write about it and fight my friends about it another 3 years. But unfortunately, the court doesn't consider my well-being, and they write these sorts of decisions. But unfortunately, we're stuck with Obamacare for the foreseeable future.
Okay, right. I did notice there was a cert grant last week on an underlying question of embedded in it. So it's certainly, if the questioner was asking, is sort of the Affordable Care Act going to continue to be a font of litigation? I think the answer is resounding yes.
Yes.
Anyone want to comment on stuff before I sort of take us to sort of the regulatory space? Because there are some interesting little nuggets and nooks and crannies there, but I don't want to truncate a conversation.
Just on the one point on the Affordable Care Act or inseverability generally, if at least on an orthodox understanding of judicial power as tied to remedies and res judicata or judgment power and reasons for judgment, only the Supreme Court can really pull off inseverability, right? No district court, they can write the words, but no district court, no circuit court can destroy the Affordable Care Act, right? In a way that would make it sort of just not law for anybody else. Like only the Supreme Court can do that just because of the way our system is structured, which is weird and makes you think that maybe no court has that power sort of just by implication, that the courts really are case and controversy and then reasons that follow from those. So just a thought. Maybe the horse is, there's no oxygen on the planet we sent that horse.
So moving to sort of the regulatory space, severability comes up in front of agencies occasionally when they want to use or anticipate litigation and challenges. So I'm curious if you guys have thoughts on how administrative agencies should think about severability. It's a little bit of a strange one, I think, because it's not exactly the same posture. The equities are a little different. But if you're advising, say, the Federal Trade Commission or another frequent flyer that does some severability moves, EPA, what should they be taking into account? I mean, we've seen this litigated in a few different contexts, and I think the Administrative Conference of the U.S. has looked at some of these issues, but what's your reaction to agencies trying to navigate or use severability to maybe protect some of their rulemakings, for example?
Maybe I'll just kick us off to say that so severability was imported into constitutional law from contract law, right? So this thing about what do you do when you have this big thing, a part of which may be no good. Contract law, it makes sense for contract law reasons. Statutes, it may make sense. For regulations, I guess in the first instance, it might be a function of the standard of review, right? So the APA 706 says set aside unlawful agency action. So if the agency action is kind of a rulemaking and that's what gets set aside rather than an enforcement or something like that. So I would say whatever an agency tries to write in is always going to be subject to whatever statutes govern it and govern then the actions by which they're challenged. So I'm not sure that it sort of just transposes. That said, and it's not just the organic statute that might matter or the APA that might matter. Take something like the Religious Freedom Restoration Act, which requires the consideration of any burdens that a regulatory action might make on the exercise of religion, and says you actually have to carve those out or figure out some rule unless you give us a reason why you can't. And so I'd say there's a lot more constraints just as a matter of statute on what agencies can do. But to the extent that you have a rule that it depends on what the agency wants, then sure, go ahead and say, we don't want our thing to die if part of it dies, say it. And if that's consistent with all the statutes, you'll be fine. But I think it's a slightly different set of problems because there's a different set of constraints.
Yeah, I think I agree with Kevin. I think the APA imposes two major changes in terms of how courts treat agencies versus how they treat Congress. So one is the APA makes courts think they are more entitled to not believe agencies even when they say something. So like the agency says, look, if part of this rule is invalid, we still want the whole rule. Courts are much more likely to say, yeah, you said that, but we'll just let you give it back to you and let you decide whether you really mean it. Right? These attempts to kind of enact fallback positions in agencies are just don't always hold up, because doesn't necessarily comply with the court's view of recent decision making. The other is that the APA gives an avenue for the courts to do what we were talking about earlier, to just give things back. Like the APA creates a sort of like, a greased path to say, all right, I'm giving this back to the agency. And especially under these kind of like innovative remedial tools. I think there have been other telefora about like remanding the rule to the agency without vacating it, which is maybe not actually allowed, but courts do it anyway. But it just makes it feel easier for the court to say, you just need to take another look at this one. So I think on the agency side, there's less value in adapting kind of like severability and inseverability clauses. Maybe there should be. I'm not sure courts should be throwing those away, but of course, they're less likely to take them seriously, and they're more likely to just call the agency later and ask ask formally what they should do. Maybe that means we need an APA for Congress, and maybe that means what we really need is a statute like that to just like we made agencies more functional, arguably with the APA. Maybe we need to make Congress more functional with a Legislative Procedure Act. But that's another day.
I like it. I like that. So we're running short on time. I did want to throw it sort of open to ask each of you to weigh in on kind of what you see coming next. Are there particular cases that you think our audience should be watching for now that they are all very passionate about severability and they want to see if Josh is right on sort of where Thomas is headed, for example? What are you guys watching for, and what would you say that our listeners / audience, what cases should they be watching for, and what do you think in the next couple of years are we going to see crystallize or continue to be disputed? I'll start picking. Let's go with Erin.
Great, thanks, Megan. So I think that I'm personally very interested in Josh's sort of standing by inseverability argument, and I'm fairly skeptical to it. Sorry, Josh.
By the way, Erin was my Fed course professor many years ago, so this is a bit of a treat.
That's impossible.
No, she had just finished clerking, I think, and she came to George Mason for a semester. So this is a bit of a treat for me.
Yeah, it's really fun. So I love the novelty of it, and I think it's super innovative. So would definitely get an A+ on it because I am. But as far as I think I share Kevin's sort of skepticism as is this really part of the judicial power? If we're looking at a different provision, is it actually harm? Does it cause harm? Is it remediable? So I do think we will see some of that raised in various cases in the lower courts, and it will be fascinating to see what the lower courts do with that. So very interested in that. I don't think ultimately it will prove successful, but very interesting.
All right, who's next on my prediction wheel? Let's go with Kevin.
Yeah, at least on my screen, I'm the next one over, but that's unreliable. But so I don't have a case for you, but I do have a kind of general thing to watch for. So Will talked about First Amendment law and the divide. Reed versus Town of Gilbert kind of makes everything turn on sort of form in some ways, and I think if we ask why now, right? Why is severability? It's not because they read my law review article. Those things show up in opinions, if they're useful to people writing them. But it's not like that, they're not. So we need an explanation internal in some ways to the way that law is being argued now that makes severability live. Now, one reason might be that they very rarely find anything inseverable. And Murphy versus NCAA was one of those rare cases. I do think that at least some members of the joint dissent, in particular Justice Thomas, kind of stared into the abyss a little bit in NFIB versus Sebelius. And my own speculation is that the prospect of inseverability contributed to the Chief Justice's second look or third look or however, to kind of like, are we going to take down this whole thing based on supposition about congressional intent when it regulates 70% of the economy, affects, Native American reservations and sort of breastfeeding rooms and menus at fast food restaurants and like everything that was in there? Are we sure that this is how law works? I think that sort of planted a seed, back then, but there wasn't an occasion as much for that to throw up some shoots, and Murphy versus NCAA perhaps had something to do with that. To say, I'm not sure. I'm pretty sure that. Well, I think it was wrong, but it made them think, why are we doing severability? But another reason is that formal tests, right, that kind of go after an entire structure or an entire set of applications, right, they result in potentially broad sets of unconstitutionality. And we might think, you had asked, Megan, if this gives a pass to Congress. We might think of severability doctrine as the justices giving themselves a little bit of a pass. Are we sure that the price of getting rid of a restriction on presidential removal power, if the price were taking down the entire PCAOB, would they have reached that? Same with the FHFA. If there were hundreds of millions of dollars that had to be given back, because that, so it might be that what we're seeing with severability is a kind of remedial equilibration where they're kind of by reducing the consequences as a practical matter of holding of unconstitutionality, they're making it easier to find things unconstitutional. So we see in areas where this court is more aggressive than past courts, First Amendment, separation of powers, that's where it's coming up. So then the thing to watch for is what happens with those who are against these more formal tests? Because so far, if that's part of what's been going on, they've been playing along. That is, they've been saying, well, I disagree with the separation of powers analysis, but I agree that it's severable. Right. I disagree with this, but I agree. Okay, send it back. And so there's one move to make, which is, now that's a sort of more cynical approach, but I do think these things fit together. And so one thing might be to just watch this relationship as it develops. And then the second is, I think it's a very interesting few years as this particular issue becomes the one where some of the newer justices and then some of the newer ideas of some of the older justices, not in chronological term, but in court term, like where they mix and match. And I think there's just it's a fascinating time to be paying attention to these things. So, maybe set a West Clip or something, or Lexus, whatever the equivalent is, for severability and enjoy the ride.
Awesome. Well, can we get some quick final thoughts from Josh and Will before Nick gives us the yank?
My prediction is watch out for these issues to spill over into non-severability topics like retroactivity and also the de facto officer doctrine, which came up recently in the Puerto Rico bankruptcy case. Ultimately, was not litigated all the way back. Presents a lot of the same kinds of dilemmas. So you'll see these opinions cited when those.
And I'll make one final point. Big business that thinks they'll kill the CFPB or kill Amendment 3, have other things to worry about. The court won't do anything. Free Enterprise Fund, bupkis. Seal of Law, bupkis. Arthrex, bupkis. Collins, bupkis. You guys get bupkis. So if your clients at Wiley, Rein, other law firms, if you look to the appointments clause and severability, you'll get nothing for it, but a lot of legal fees you'll never get back.
Well, on that depressing note, thank you, Professor Blackman. Thanks to our audience for dialing in. Thanks to all four of you for a great conversation. Erin, Will, Josh, and Kevin, that was great. You made me look good, so thank you. And thanks, Nick. And I think with that, we're done, right?
Yeah, thanks very much. Megan covered it. I just get to offer the official Federalist Society thanks. Thanks very much for your valuable time and your valuable expertise. Of course, to our audience for dialing in. Keep an eye on your emails and our website for announcements about upcoming events. Not quite like this one, but registration information for future events. So thank you all for joining us today. Until that next event, we are adjourned.